we obviously recognise you all hold very senior judicial positions, which will affect the kind of things you want to comment on, or perhaps how you want to comment on them. But we will fully understand that. And I'm going to ask, I'm going to ask there are two members who might have interest to declare. Mr. Buckland.
Yes, thank you, Chairman. I have been a practising barrister for 20 years, primarily in the field of criminal legal aid. I still have a practising certificate, but I don't do any new cases at the moment, and I sit as a recorder of the Crown Court.
Ms. Gresham.
Yes, I was a barrister before becoming a Member of Parliament. I mean, I still am, but I've actually returned my practising certificate. Before that, I received receipts from the criminal legal as well as from some civil work as well that I used to do.
Thank you very much. Now, to Mr. Buckland to start the questions.
Yes, thank you. We're focusing today, gentlemen, on access to justice and the potential impact of the proposed legal aid reforms to that. And I just want to open with some general observations you may be able to help the committee with. It's been said, and in fact the statistics seem to bear it out, that we are spending more per head in England and Wales on legal aid than in other comparable jurisdictions, whether they be common law or jurisdictions within Europe. And I'd be grateful for any thoughts you may have as to why that should be, first of all.
We're here, I hope, to speak on account of our respective major jurisdictions.
Yes.
I'm President of the Queen's Bench Division, and I'm reckoned to be here principally on account of the Administrative Court. Sir Nicholas Wall is here on account of the family, and Judge Martin on account of tribunals. We obviously have experience of other parts of the business, and I dare say that criminal legal aid is a contributor to the large amount of money that is spent on legal aid, and I wouldn't myself reckon to say very much about criminal legal aid today. I would, however, say that I think there are diverse reasons for the expenditure of legal aid in various parts of the judicial system, and they're not all the same. I'm personally convinced, and this is a personal statement, not a representative statement, that one function which necessarily increases expenditure, be it legal aid or private expenditure, is the time that cases take. And we've had a clear experience over the past 10, 15, perhaps 20 years, where cases which 20 years ago would take 3 or 4 days are now taking 2 or 3 weeks. There is also, I think, in some parts of the justice system, a multiplication of complexity and a multiplication of the number of parties. And it's fairly obvious that if you have a very complex criminal case with 6 defendants, each of whom are separately represented, you're going to have 6 lots of legal aid on a case which, if it were more, shall I say, economically prosecuted, would not be so expensive and would not last so long. That's a statement outside my specific sphere, but I think all of us have experienced that. When it comes to the administrative court, cases in the administrative court on the whole do not last a very long time, and cases in excess of a day are quite relatively rare. But expenditure on legal aid, where it exists in the administrative court, occurs in large measure because there are so many cases, and one case lasting a day is going to cost a day's amount, but 5,000 cases each lasting a day is going to cost a great deal of money, particularly where some of those don't come to court. I don't know whether the President of the Family Division would like to enlarge on that.
Thank you, sir.
The only point I'd add in addition, I think, is that there's been a very substantial increase in the volume of work in the Family Division in the last few years, particularly in the public law sphere. And, of course, that is out with our control.
Judge Martin.
It may in part be a function of the amount of legislation and regulation. I can give you a specific example from my own tribunal. which 2 years ago was dealing with something like 240,000 cases a year. This year we expect to reach nearly 400,000. The main driver in that increase is a government programme, Welfare to Work, and the conversion from incapacity benefit to employment and support allowance, which has driven most of that increase.
I've been toying with the thought that the departments which create a great deal of extra work perhaps should be a source of funds for the costs arising from it. If it should be on their budget, they might start to notice.
In the case of the Department for Work and Pension, it does, in the Ministry of Justice, to my understanding, cross-charges some of that. But where there might be scope for change would be if the charge made reflected the quality of the original decisions that are coming before the tribunal.
I don't know whether Judge Martin would be able to help us. That was a very interesting comment you made about the cross-funding. You may be able to help us as to where we can get hold of those figures, because on the most recent analysis of legal aid for 0809, for legal help with regard to welfare work, I think just over 27 million was spent by the LSC on legal help. The proportion for legal representation was dramatically smaller than that, it's fair to say. But I thought that figure was quite striking. I don't know what your view is on
striking
that.
For its modesty.
Well, I thought, first of all, the difference between representation and help was striking. But what it said to me, and you may correct me if I'm wrong, is that far too often the error and the mischief, if you like, is further back in the system, errors within the DWP and the whole system itself, which then have to be ironed out by the lawyers. Would that be a fair characterisation of the situation?
I think so. I think it's a theme that ought to occur throughout the consultation paper to make an intervention in terms of public funding where it will have the most consequence. And that might be towards the start of any dispute, the start of any case, rather than further down the line, because if it can be resolved very early on in that process, it's probably cheaper and to the benefit of all concerned.
As I say, if you do have access to those figures, we'd be very grateful.
I will endeavour to forward those to you.
I'm very grateful, Judge Martin.
You might be interested to know that in previous times the committee did look in some detail at the work of entry clearance officers, particularly because the large number of successfully challenged decisions suggested there was something wrong with the decision-making process.
Yes, following on from that particular area, I've mentioned the figures about legal aid being higher than other jurisdictions, but the converse of that are shown by a study commissioned for the Ministry of Justice by the University of York fairly recently, showed that in contrast to other countries, the costs of judicial administration and the courts were lower. Do you think that these proposals, the proposed cuts to legal aid, could have an impact upon costs within the court system?
Yes, I do, and I think it's variable between the jurisdictions that we represent. If legal aid, public funding of claims in court is reduced, there will be an increase in the number of unrepresented litigants. The general experience is that unrepresented litigants, on the whole, there are some very good unrepresented litigants who present their cases well and who prepare their cases well and who concentrate on the main issues, but there are a large number of them who do not, and who therefore necessarily increase the time and to some extent the expenditure that the court system has to spend on them. It is, however, I think variable between jurisdictions. Sir Nicholas Wall will tell you about what happens in the family jurisdiction. In the administrative court, I'm fairly clear that if there were a reduction in public funding of classes of case that might come in the administrative court, yes, there would be an increase in the number of unrepresented litigants, but it would to some extent be balanced by a reduction in the total number of cases that the court had to deal with. Because I think it's quite clear that in some respects litigation is engendered, at least in part, by the very availability of public funding, and that if public funding were not available, some of these cases would not reach the court at all. That may be a good thing, it may be a bad thing. It would certainly be a bad thing if meritorious cases were unable to be brought when they should be brought. But the experience we have is that quite a number of our statistically difficult list is occupied by cases of little merit, and if some of those never arrived, there wouldn't be much detriment to access to justice. But the family position, I think, is different.
Yes, I think in family law, if public funding is removed from private law applications, which is played on the cards, then there'll be a massive increase in litigants in person, because if you want maintenance, or you want to be maintained, or you want to have contact with your children, or you want to look after your children, you're not going to be prevented from doing so but by an absence of public funding. We are doing our best in the private law programme to ensure that at the first appointment in any child case, the district judge and the Kafka's officer attempt to resolve the issue and identify the issue and, if necessary, settle it. But there's undoubtedly going to be a card full of insoluble cases, which are going to take much longer, they're going to be much more difficult to try, and the litigants in person will proliferate. And I think it's quite clear from the Green Paper doesn't really recognise that as a problem, which undoubtedly does exist. Every day of the week you talk to any judge who tries family cases, you'll find parents appearing in person. Sometimes, in a very difficult case, the child is represented, but the case takes longer, it's much more difficult, you have to explain, you can't take shortcuts, you have to explain, you have to be courteous, you have to follow everything, you have to cross every T and dot every I, and that takes a great deal of time, and it will take more time in the family justice system.
I think Mr. Gummer wants to come on.
No, I won't follow up on that. And I don't want to put you in a difficult position, but the Ministry of Justice has claimed to this committee and to others that the offset, as they've suggested, in the time that you will spend litigants in person will be effectively balanced, so that the cost of the court in time and money will be equal. Now, everyone else but the Ministry of Justice has professed some surprise at this. Do you agree with them or not?
I share the surprise.
I share the surprise in part, because I do think that to some extent there will be a balancing out. I think the likelihood is that if there were, if legal aid was withdrawn in administrative court cases, one needs to identify what they would be. You would get an increase in unrepresented litigants, and those individual cases would take longer and require more court, judicial and administrative time. But I do actually believe that there would be fewer cases.
One of the other differences, of course, is ancillary relief. That private law is not limited to the question of children, it's a question of money. And if married parents separate, they want to sort out their finances. One of the aspects which concerns me most is not only the withdrawal of public funding from that whole sphere, or the proposed withdrawal of public funding, but also the fact that legal advice is not available or will not be available. And what we in the family justice rely very strongly on the lawyers to give sensible, practical, down-to-earth advice which settles cases. Most people settle their cases, it's only the minority that fight. But with the absence of any advice, it seems to me the likelihood is that more cases will be contested. More cases will be contested on the basis of no legal representation. That will take longer, it will be more difficult, and it will slow the whole process down very substantially.
I was wondering if Judge Martin thought that the position of unrepresented litigants was different in the tribunal sphere, given that many were surely created on the assumption that they would not require representation.
Position varies across tribunals. At the moment, legal aid isn't available for representation in many tribunals. In the Social Security Tribunal, 72% of appellants are not represented at the moment. I think that the proposal to reduce legal help will have a big change
It won't affect, I think, as much the number of appeals that go forward, but it will change the nature of them. We will see more people with cases with no prospects of success because they haven't been filtered out as they are at the moment through good advice. We suspect that many citizens with winnable cases won't reach the tribunal because, again, they're not getting the effective support at that early stage. And the absence of legal help also means that cases will tend to be less well prepared for the tribunal, which will extend the amount of time we have to invest in the case to make sure that a good outcome is reached.
Mr. Buckley, sorry.
Yes, can I ask some questions specifically to Sir Nicholas because they relate to private family law, and you've already touched on it. This committee is particularly interested in the focus in the Green Paper upon the definition of domestic violence. It seems, on the basis of the Green Paper proposal, that's going to be a key, if not the key criterion for the determination of whether or not a case is in scope or not. It hasn't escaped this committee's notice that there seem to be several definitions of domestic violence, to say the least, between different areas of government and in particular disciplines. I was wondering, and I'd be very grateful for your view as to where we are with the definition of domestic violence, what your view is of it, and what we need to do to try and create a better and clearer criteria.
Well, I think the government is very ill-advised to concentrate on violence in the context of domestic violence. Domestic abuse is the term which we use currently, because much domestic abuse is not violent. It's psychological, it's often financial, it's often emotional, it's not physical. And there is a perverse incentive, it seems to me, in the proposals put forward in the Green Paper, that people who will be obliged to take out injunctive proceedings against a former spouse will be obliged to litigate in order to open the gateway to legal aid. And so much, as you know only too well, so much domestic abuse is hidden. It's not actually brought into the public domain. It's not brought forward into police action. It's not brought into prosecution. And so there's a perverse incentive not only to litigate, to obtain an injunction, but also to make allegations of domestic violence as opposed to abuse in order to open the gateway to legal aid. And I think that is very detrimental. Equally detrimental is the fact that we won't apparently be good enough, according to the Green Paper, to settle. Most injunctions these days are dealt with by way of undertakings. A man will frequently say, I undertake not to assault or molest in the future, irrespective of my conduct in the past. That undertaking is accepted by the court, and the case proceeds on the basis of that undertaking. Well, that will no longer be possible. We will be forced into litigation on injunctive issues, and we will be forced, if the Green Paper stands, to deal with abuse in terms of violence, when abuse is much broader, and the ACPO definition of domestic abuse is much, much broader than physical violence, and indeed common sense dictates. We all know that domestic abuse is much broader than domestic violence, and so it's most unfortunate, it seems to me, the government has concentrated on violence in this context.
And what would you make of the other issue as well? There seems to be a lack of clarity about whether it should be violence or violence between adults as opposed to involving the children of
Absolutely.
the family.
At the moment, as I read the Green Paper, it's limited to the applicant. And of course, much domestic abuse is directed at children. Much domestic abuse is directed at third parties, and there's a lack of clarity, it seems to me, in the proposals. And I would be very reluctant to see a system which denies access to justice to the most needy people who really who are in desperate need of assistance because they're the victims of abuse, but they haven't gone through, they haven't ticked the right boxes, or haven't gone through the right moves.
Yes. And as I read it, there's the criteria involve a time limit of 12 months.
Yeah.
The preceding 12 months, there would have had to be proceedings. So
Yeah.
conceivably on December the 31st, 2009, if there'd been concluded proceedings then and there'd been violence or abuse on the 1st of January 2011, there would be a problem in terms of scope.
That's how I read it the same way. I mean, all deadlines produce anomalies. But I mean, at the moment, when one deals with the case purely on the basis of merit, and judges are usually very good at assessing merit, and it troubles me that this is an artificial standard being imposed.
Now, again, there's been much discussion about mediation, and I'd be very grateful for your assistance here as to where in the system you think that could come in, and can mediation operate without legal help? In other words, could it be just a direct alternative to any legal input?
Well, mediation works best with legal help. Most mediators, I will tell you that they like their clients to have good legal advice, particularly if you're doing all issues of mediation and you're mediating on money as well as on children. We have just agreed that the government is very keen on a pre-action protocol, which means that anyone who's applying for a private law applicator order has to go to a meeting or seek a meeting with a mediator if it can be arranged within so many miles or so many days of issuing the application. The private law programme, that may take some people out of the system. Mediation is simply one of many very good alternative dispute resolution procedures, and as I already mentioned earlier, at the first appointment, many of the mediators actually get their mediations because at the first appointment the judge says, or the district judge says, or the CAF case officer says, why don't you try mediation to resolve this dispute? It's much better you should do so. So mediation is one of the factors which in alternative dispute resolution, but it's by no means a panacea. And I think, to be fair to the mediators, they will say to you it's not a panacea. They will say that it's very good for a particular category of case where both parties are willing to discuss the issue frankly and openly and make concessions, but it's not a panacea by any sense of the term.
If I may, Sir Anna, I mean, on that point, the Lord Chief Justice, I don't want to misquote it, but has suggested that the adversarial system is not helpful in almost any circumstance in the resolution of private family law cases. I wonder how we can fill the gap, therefore, between that suggestion and the idea that mediation would solve everything or not. And, of course, that's what the Lord Chancellor has picked up on in his submissions to Parliament.
Yes, well, there are cases, there are times when the adversarial approach is inevitable. For example, if you're finding facts and you have to make a finding of fact, then you have to have the two cases put before you and you have to decide between them, and there's no alternative. I think we've long recognised that in many family law disputes, particularly related to children, the adversarial system is unhelpful. It encourages parents to recriminate, it encourages parents to use their children as ammunition and a battleground. And that's why we've introduced the private law programme, why we have parenting information programmes, and why we encourage mediation and alternative dispute resolution. So I think one of the difficulties the family law system operates under is that it was grafted on to the common law system and inherited a lot of its aspects. And we are the first to recognise that certain aspects of those don't fit with family justice. And that's why, as I say, we've gone for alternative dispute resolution. And why the judge in a family case, as opposed to a Green's Bench action, may be much more inquisitorial than the traditional role of the judge, which is simply to sit back and listen to the argument and the evidence and make a decision. Judges manage cases, they intervene in cases much more. And of course, I suspect with litigants in person, we're going to have to try and do even more than we've done already.
Is there scope to take that further?
Yes.
Could that be done to a greater extent and thereby reduce the requirement for a whole series of representatives, one for each parent, one for the child, all to argue over things which the judge could perfectly well surely ask the parties?
Well, the child, in private law proceedings, the child is very rarely represented. Only if the case is one of extreme difficulty is the child separately represented. So in private law disputes, you tend to be parent against parent. But as I say, all the effort is going into alternative dispute resolution. If it fails, and it will fail in a number of cases, then there will be no alternative but for the judge to decide the issue. We will be left with this card of very difficult family cases, which we will have to adjudicate on. And they will take time, and they'll be slow, and they'll be difficult, and they'll be expensive.
But could I press you again on that? I think the point is, you say it's been grafted onto the common law. Is there something that we could do rather more radical about the distribution of family justice and actually just accept we have to have an inquisitorial system?
Well, we're waiting for, of course, the Norm Grove review. Judges in public law cases are already case managers, taking a much more active inquisitorial role. And I think there is a recognition that in private law cases, ADR has a very substantial role to play. The difficulty is, what is the alternative? Is the judge to become the French inquisitorial judge who gets off the bench, goes around and opens the fridge and has a drink with the child in the home? You know, I mean, we are where we are. We're part of a common law system, and unless you, my mind is entirely open on that. But that would be a very radical change if we were to hive ourselves off and become exclusively inquisitorial.
It's Trish.
Yeah, I was going to say, as somebody who's very much a champion of the adversarial system, can I just ask, in relation to family law matters, I mean, there's talk about the civil legal aid, but is it not right that in the last 2-3 years there's been a lot more cases where children have been taken into care, which has resulted in perhaps a lot of money being spent in the civil legal aid funding for family law cases? Because I certainly have had experience of a lot of counsel saying to me that they've taken a lot more children into care as a result of the Baby Columbia case and Baby P case. And hasn't that been one of the factors that's increased the amount of civil legal aid?
Well, it's increased the amount of public funding, there's no doubt about that, but there's no proposal of the Green Paper, I'm relieved to say, to interfere with that. Because when the state intervenes in the life of a child, the parents have a right to be represented, as does the child, and the child is always separately represented in public law proceedings. And the state has to justify removing the child from parental care, and the very clear criteria laid down for that. So I don't think that... What is surprising about Baby P is that one expected a peak after Baby P, but one hasn't had it. There's been a peak and it's been maintained. One expected a peak and then a trough again, and things to go back to normal. They haven't. The work has increased exponentially throughout the period since Baby P. I don't know whether that's been the same in other fields, but certainly it's caused enormous difficulties in public funding because, as you rightly say, a huge amount of money has had to be spent, and these cases are all publicly funded. It has had to be spent on local authority interventions. Local authorities have become much less risk averse.
Would you like to go on to the other area?
Go on to my own. Yeah. Just discussing on areas of law which the government is proposing the legal aid would not cover anymore, such as education, employment, housing, immigration. And just wanted to ascertain from you that it's been suggested by the Legal Aid Practitioners Group that the proposal to remove funding for education would cause a lot of problems, because at the moment 92% of education cases are successful. A majority of them relate to young people with special educational needs cases. Would you fear that there'd be a real adverse effect on certainly that particular area of the law if the legal aid was taken away?
Yes, I agree that it will have a major impact on the Special Educational Needs Tribunal. It's a high rate of success, but what would counter success is any change in the original decision which is of benefit to the appellant. And I think without legal advice, because representation wouldn't be covered, there is a risk that more polarised positions would be taken and there would be less willingness to compromise or to go down the mediation route, because the unadvised litigants in person would not really be in a position to evaluate an offer that had been made or compromised. They would tend to say, well, we go for the whole aim of our claim. So I think that there will be adverse effects, not only because it may make it more antagonistic, but it's likely, in my view, to leave the unrepresented appellant feeling that the proceedings have been less than fair because of an inequality of arms. On the one side, the local authority will have access to educational experts, will have reports prepared. On the other, you're put in that defensive position of only being able really to challenge or dispute someone else's evidence, and wouldn't be in a position to put forward alternative proposals by being able to afford your own expert evidence. So I think it will have an adverse impact.
Isn't a 92% success rate an indication of an appalling decision-making process?
Well, it could...
by the body against which the appeals are being made.
It may be that the local authority takes the view that the child concern doesn't warrant any special assistance. The parents may feel that the child should have 24 hours a week special teaching. If there's a success in gaining 1 hour, then it may rank as success. So that might reflect it, that it's changed the original decision, but only partly in favour of what the appellant would see as a fair outcome.
And continuing on from that, we've got the immigration tribunals where quite often there are quite complex issues going, nationality, asylum and others. Do you foresee that if there wasn't legal representation, that may lead to a lot more possibly appeals, a lot more application for judicial review to the divisional court?
Yes, perhaps we can take that in two parts. And you
could I try to deal with that? It's quite complicated, and I hope you'll forgive me if I do some background and expand on the question a bit. The administrative court 2 years ago, in the calendar year 2009, had nearly 16,000 claims of various sorts. Of those, about 7,500 were asylum claims or similar. And when I became president of the Queen's Bench Division, the administrative court was in danger of being overwhelmed administratively by asylum-related litigation. The government legislated by, among other matters, repealing Section 103A of the Nationality, Immigration and Asylum Act 2002. That alone had been responsible for about 5,000 of the 7,500 cases before 2009, which were classed as reconsiderations, and they were, in essence, last ditch, perhaps that's not a very fortunate expression, end of the road applications attempting to establish a claim for asylum, where that claim for asylum had failed before the Secretary of State, had failed before the Asylum and Immigration Tribunal, as it then was, and had failed in an appeal system. And the form in which those cases came until 2 years ago was by means of reconsideration applications under Section 103A. At the same time as the tribunal service was set up in its modern form, with first-tier tribunals and upper-tier tribunals, the Asylum and Immigration Tribunal went to the tribunal system, and there was grafted onto it the standard first-tier, upper-tier appeal system. And in asylum cases, that is supposed to operate in the main with a Secretary of State's decision, an appeal to the first-tier tribunal, an appeal to the upper tribunal if permission is granted, and that's important. I'm sorry to be a bit complicated, but it's quite important to get to the end of this. And then if there's a point of law which should go beyond an appeal to the Court of Appeal. So that would be an orderly progression of appeals in cases where permission is granted through the tribunal system up to the Court of Appeal, and the Administrative Court wouldn't enter into it at all, thereby a reduction in this very large number of cases coming to the Administrative Court. And this was shown up, that the nearly 16,000 cases in 2009 reduced to 13,500 cases in 2010. But there has grown up a kind of surrogate version of the reconsideration application, which we now have to shoulder the administrative burden of, which are applications by failed asylum seekers who are on the verge of being removed by UKBA removal activity, who apply very often at the last moment, within just a few hours before the plane is about to depart, to a judge of the administrative court seeking a stay on their removal. And we have to deal with sometimes 20, even more, such applications every day when there's a charter flight going out of Gatwick, Stansted, or wherever it is. And these, as it were, are a substitute inflow of these latter-day applications, a large number of which have no merit whatever, but a few of which do have merit. And let us say that 85% of them, that's a figure I rather pluck out of the air, but it's of that order, are of no merit, and are in cases where an appropriate decision-making process, including an appeal and including the opportunity of applying for a second appeal, has taken place. Against that background, you have the proposal that the government has put forward to remove legal aid in immigration cases, but to retain it in asylum cases. In the main, the cases that I'm talking about are asylum cases. But the critical point is that at the moment, the law is that you cannot bring judicial review proceedings to the administrative court from a refusal of permission to appeal from the lower tier tribunal to the upper tier tribunal. And that applies just as much in immigration cases as it does in asylum cases. However, that's the law in England and Wales, but it's not the law in Scotland, because the Scottish courts have reached a different decision on this particular point. And the disparity between the law of England and Wales on the one hand and Scotland on the other is coming up for decision in the Supreme Court in March. If the Supreme Court decides that Scotland is right and England is wrong, then there will be the opportunity for all these cases, which used to be reconsiderations, to come by way of judicial review to the administrative court. And in the legal aid context, and I'm sorry to have been so long, but this is the point. In the legal aid context, you have these two, one fact and one prospective possible fact. The last-minute applications in the case of charter flights are brought with the benefit of public funding and would, unless a change is made, as I understand it, continue to be brought with the benefit of public funding. But these are cases that have been through the system where 85% of them are of little or no merit. And I personally think that consideration could properly be given to whether some mechanism might not be found to moderate the availability of public funding in that respect. That's the first point. The second point is that if CART, the case in the Supreme Court is called CART, if CART is decided to the effect that Scotland is right and England is wrong, then because the proposal is that judicial review will continue to qualify for legal aid, all these applications which we can foresee would happen would qualify for legal aid, and you would get a whole lot of immigration cases, which you, at the moment, the proposal is they should not have legal aid, getting legal aid not because they were immigration cases, but because they were judicial review applications. And if you want my tentative suggestion as to how the first of those problems might be dealt with, it would need mature consideration. There is a well-worn procedure in the Court of Appeal Criminal Division in relation to applications for leave to appeal to the Court of Appeal Criminal Division, where the leave has been refused by a single judge on paper. The system is that public funding for a defendant in criminal proceedings who is convicted and sentenced, the public funding for the first instance proceedings extends to the giving of advice in relation to an appeal, and will therefore sustain the lodging of an application for leave to appeal to the Court of Appeal Criminal Division, and that happens every day of the week. If that application fails on paper, the application can be renewed orally before the full CACD, but that is at risk as to public funding. And the way it works generally is that the application is made without the benefit of public funding. If it succeeds, public funding will, generally speaking, be granted for the succeeding appeal. But if it fails, the lawyers don't get paid for what they've done. Now, I don't see why an equivalent system couldn't be put in place in relation to these late asylum applications. They are actually applications for a stay in an asylum case, so the proposals would result in them being publicly funded as they are at the moment. But if that particular variety of application did not qualify for legal aid unless it was successful and the judge said so, then the amount of legal aid on those cases would be reduced by about 85%, and there are 5,000 of those cases every year. And it seems to me that is a proper means of doing it. And I have to, as it were, declare the interest that my administrative interest is to reduce the number of these cases. That's not nothing to do with how they should be decided. We just have an influx of these cases that it's very difficult to deal with. So I, in a sense, by virtue of my office, have an interest in that. But it seems to me that that's something which should be considered. I'm sorry to disturb you.
That's a very interesting point. It caused me to muse as to whether the Secretary of State, the Lord Chancellor, is represented in the court proceedings in respect of potential cost arising from the outcome.
I'm sure that the Secretary of State is deeply interested in the court proceedings.
No, I think.
Did we want to come in on this point?
Well, I did. As somebody who's been in the Court of Appeal in criminal cases with both scenarios, frankly, either having had leave granted after refusal by the single judge or not, as is the case in some instances where I've had to return home empty-handed. Your suggestion has a lot of merit. Could that be extended to other areas, do you think? I know that generally there's a leave procedure anyway, or a permission procedure when it comes to applications for judicial review, but could that principle be extended to other areas of administration?
Well, I'm sure you could. I'm sure one could think about it. All judicial review proceedings require permission. Generally speaking, if an application for permission is refused, the question of costs doesn't arise. Of awarding costs doesn't arise, but a lot of these applications will have been publicly funded and therefore will have cost the Legal Services Commission money. Whether I doubt, off the top of my head, if a proposal to limit public funding for all judicial review applications, irrespective of their nature and irrespective of their merit, would receive much backing. I mean, there's such a wide variety of these applications that one would find it very difficult to put in place something as sweeping as that. On the other hand, I do think that if an economical system could be put in place where legal aid was available for meritorious claims but not available for claims which had no merit, that would be of advantage.
Thank you.
Mr. Governor,
but you've almost answered the question I was going to ask, because the contention of the Lord Chancellor is that the Ministry didn't want to take judicial review out of scope precisely for the reason that you have mentioned, but you have given one instance where it's perfectly possible to do so and not to jeopardise the rights of citizens, their relationship with the state. So, by extension, there must be other areas within judicial review where it is possible to do that without jeopardising that.
Thinking on my feet, if you have an asylum decision by the Secretary of State, which then is appealed to the first-tier tribunal and the appeal fails, and there is then an application for permission to appeal that decision, it's at least a question worth asking whether public funding for that application might or might not be considered. But the analogy with the criminal side of it is that the application for permission ought to carry on the back of the public funding for the first instance appeal.
Thank you very much.
If I can turn back to tribunals for a moment. Clearly, two things I want to say about tribunals. First of all, that they have expanded with the state's decision-making activity and its willingness to grant some kind of appeal mechanism for decisions which have a big impact on the lives of individuals or families. But generally speaking, many of them, when they were created, were meant to be user-friendly and not to generate the sort of proceedings that would be normal in a court of law, even though they have some of the legal basis of a court of law. Is that... do we no longer view tribunals in that light? Are we simply now treating them as like any other court of law?
How times change. The complexity of the law has multiplied. When social security tribunals were first set up, at that stage I was an advisor, the law that we used was encapsulated in a very slim handbook. The reference materials that we issue to our tribunals now extend to 7,500 pages, spread over 6 volumes. The ability of tribunals to act in that simple, accessible, informable way is not assisted when the law itself becomes increasingly complex. We endeavour to live up to the original reasons justifying tribunals of being informal, but that is against the formality of the courts. For many of the people who appear unrepresented, it's still a very daunting, stressful experience, no matter how friendly we try to be. And we still preserve the notion that tribunals should be expert bodies, and therefore it is easier for a person who hasn't had the benefit of professional representation to set out their case, to be able to present their case, because the tribunal itself will adopt an enabling role. But there are limitations to what we can do. And one of those limitations is that this is a criticism of the proposal in the consultation paper, which says you should look at the ability of a citizen to present his or her case. Really what we need is assistance in the ability to handle the entirety of the case, because so much groundwork has to be done before someone actually gets to the door of the tribunal. And that's where I have a concern that the removal of legal help from so many areas of activity in the tribunal will set people off handicapped on their ability to win their case.
Will it bring more people into the tribunal because they haven't been advised that their case has no chance of success in the tribunal?
Yes, because the general public awareness of tribunals is very low, because very little is put into public education of the law and how to seek redress for grievances. And there is this risk that we will see many people who have been drawn to the tribunal believing it's the most appropriate forum to solve things, whereas it may be just a mistaken conception about the tribunal. Legal help is so important in that triage function of sifting out cases which can be redressed but not through the tribunal or the court, and assisting those cases where the tribunal or court can assist
to have the case prepared in a way that actually maximises the chance of success.
It's not always lawyers, though, is it? It's often trade union officials or welfare rights advisors who can point the client to the aspect of the case which needs to be brought out.
Yes, the majority of legal help in the social security field is carried out by welfare rights advisors, citizens advice bureaus. In the employment field, obviously, trade unions are to the fore. One of the beneficial changes in the legal scheme over the year has been the extension of public legal funding to cases where specialist help is not necessarily that of a solicitor or barrister, but someone who has particular expertise in that field, whether it's housing, social security, welfare, education.
And can the tribunal and its office, its staff, do more to say to people what the tribunal will want to establish in your case is whether or not X, whatever X may be, and that is what you need to concentrate on and satisfy the tribunal on if you are to win your appeal?
So much of a tribunal hearing at the moment is taken up with general information and education. What is going to happen next in the tribunal, what the tribunal needs to concentrate on. Because for the appellant, they are there because they feel that they have not been treated fairly. A decision has been taken that they don't think is right, but don't necessarily have the ability to translate that into what the law might regard as the appropriate outcome for them. So we spend a lot of time in each hearing explaining exactly what the tribunal can and cannot do. We endeavour to allow people to have their full say and in effect clear their chest of what they believe the issues are, but then to try and steer that into what the law allows us to take into account or ignore. And with the removal of legal help, we'll have to spend a lot more of the time explaining simply what the tribunal is about, rather than getting to the heart of the matter.
And it has been put to us by one witness, and probably the same view shared by some other organisations, that there is an inequality of arms in a tribunal situation if one side, whether it be a government department or an employer, is legally represented and the other is not. Do you regard it as an inequality of arms, an Article 8 issue, if you like, or is that something that the tribunal can satisfactorily compensate for?
There's an inequality of arms in different ways. The amount of preparation that can be put into a case varies according to the resources, so that if you're coming up against a government department, whether it's the Department for Work and Pensions or a local authority in special education needs, or I could extend that to say in an employment tribunal where the employer in effect is able to set off the costs of representation against tax, and then there is a disadvantage in that way. There is an inequality of arms to that extent. The tribunal will endeavour to rectify that by assisting a disadvantaged party to present their case effectively, but we maintain a balance between trying to even up the two parties to the appeal without at the same time being overly seen as leaning over backwards in a way that might be perceived as bias in favour of one party rather than another.
Was I think understood that the tribunal, when parties come before it, obviously tries to offer as much assistance it can. But of course, one of the problems lies is that when someone is preparing their case for the tribunal, they need to have advice as to how to get about gathering their bit of evidence to prove their case. And if there's no legal aid or no legal mechanism, what system exists to help them?
Yes. In many cases where Social Security appeal turns on a person's state of health, we see an appeal letter or a correspondence from the appellant which says, my GP knows all about my health problems, you're quite free to ring him or her up and he will tell you. but the tribunal really is in that position to pick up the phone and interrupt a GP surgery and say we have an appeal on at the moment. Where legal help comes in is that the advice worker can say the tribunal won't be doing that. I can do that for you and possibly even pay for a short medical report, so that the person then arrives at the tribunal equipped with that evidence.
Mr. Gallagher.
Thank you, sir. The government seems to have advanced its case for reform with three statements which are repeated. The first being that there is a deficit, and we all agree with that, and the second being that reform is possible cost-wise, apropos the increase in the use of mediation. That has caused some surprise, as we agreed earlier. And the third is that we have a very expensive system in this country. And yet their own evidence, which presented them by the University of York 2 years ago, suggests that, in fact, that isn't a conclusion that you could come to with great certainty, that the cost of the courts in this country is considerably lower than in other jurisdictions, and that it's an unfair comparison in any case because of the relative difference in deprivation in this country compared with some other common law jurisdictions. I wondered if you could comment on that last statement.
I'm not personally very well informed about comparative costs in other jurisdictions. What I think strikes a chord with me when you ask the question is the underlying implication that if the cost of legal representation, publicly funded legal representation, is reduced, there will be an increase in the cost of publicly funded courts. I don't see that as actually happening, because it is perfectly obvious in circumstances where, as with so many other public services, the cost of the court administration is running in the opposite direction, and where there is no prospect, as we see it at the minute, of the number of judges being increased in any jurisdiction really, but certainly not in those jurisdictions with which I'm concerned. The effect, it seems to me, is not likely to be an increase in the cost of the justice system, but an increase in the pressure that is put on the judicial side of it, and importantly on the administrative side of it. And I think that there has to be a danger that a rather indeterminate spin-off consequence would be that the actual quality of the justice which is delivered will be in danger of reducing. It may be in danger of reducing because the administrative preparation that is provided to the judges is not so great. It may be in danger of reducing, God help us, because the judges are under so much greater pressure that they actually have to do cases in a shorter time than they really ought to be given, and that kind of thing. And it is terribly important, I think, that a reduction in the expenditure on the justice system, however it is effected, can only take place in the end by either reducing the number of cases, which in certain instances is a possibility but others is a complete impossibility, or in extending the time that these cases take, because the only thing that one can do with the same number of cases but a smaller resource to deal with them is to extend the waiting times.
I think, can I just add, yes. I do think that there is not an adequate appreciation of the pressure the family justice system is under at the moment already, with succession of cuts, with succession of very low fees for lawyers, and the pressure on the circuit bench, particularly the district bench, who do the majority of this work in the county court, is enormous. And I have great anxiety, not just for the quality of justice, but for the health and well-being of the judges if they are put under additional pressure.
As you say, one of the goals in the consultation paper is to refocus the funding on the most disadvantaged, the most vulnerable.
But I think the strategy adopted is completely ineffectual in doing that by focusing on categories of law rather than real-life individuals. If I can illustrate this, community care will be left within scope because it's said to be directed towards those who are elderly, frail, disabled, but what would be taken out of scope is attendance allowance, which is a benefit designed for people who are elderly, frail and disabled. And one of the differences may be that the payment of attendance allowance would allow an elderly disabled person to remain in their own home. And if you remove that, it has a knock-on effect because then they may be displaced into residential care, which is much more expensive. So it seems to be a failure to actually refocus upon those who are the most disadvantaged and fail to bring into account the knock-on economic effects of not supporting people quite cheaply, I believe, through effective legal aid.
Bearing that in mind, I'd ask about one perhaps slightly exasperated question, which is, why is it that a decision that someone needs attendance allowance can't be well made in the first place, and then subject to a process which doesn't necessitate a lawyer advising the person on what method he would have to employ to challenge the decision, or a lawyer appearing at a tribunal in order to advocate a different outcome? Surely it's that very personal, very vital decision can be made in some better way, can it not?
And when we reach that golden age, we can not only say goodbye to legal aid, but to lawyers in courts and tribunals as well.
Thank you very much. We're very grateful to all three of you for your help this afternoon.
Could I just say,
Sir Anthony.
Simply as a matter of information, the Judges' Council, or more strictly a subcommittee of the Judges' Council on behalf of the Judges' Council, is about this week to submit a written response to the consultation paper. I think the deadline is next Monday, and that deadline will be achieved. I've seen this document in draft. It covers a very large proportion of the entire consultation paper, and I'm sure that it will be published and be useful.
Well, we certainly hope to take note of that and to allow it to affect our thinking at the final stages of what's going to be a very short process, but that should be in time for us to do so.
It'll come to the consultation this week.
Excellent. Thank you very much indeed. We have